we're going to look at some of the grounds for judicial review, some pre-action considerations, and then looking at things from both sides of the fence, both how to bring judicial review proceedings aimed at those of you who might work primarily for claimants, how to defend judicial review proceedings, those of you who sit on the other side of the fence, particularly local authorities, remedies, and then finish off with some top tips. The idea has been really to give a broad brush overview of this topic, because it's one that, in my view, is often overcomplicated, or at least seen as very overly complicated, but actually is incredibly, incredibly simple. I would go as boldly and as far as to say this is one of the most simple areas of law that there is in terms of just looking at the judicial review process. What makes it so much more complicated, or can make it more complicated, is that it brings in other factors. So, for example, the judicial review process is and can be, in my view, very straightforward, but because it looks at how other decisions are made, you're then bringing in a whole other set of other processes, and it's there that we get the complexity, and it's there that often people can feel put off. The advice that I would give at the outset, and hopefully what you can take away from this talk today, is by sticking with a view clearly, or keeping clearly in view, the very basic overline of judicial review and that process, some of that other complexity can fall away and really not be allowed to cloud our judgment. So what is judicial review? As I've just touched upon, it's a review of, it focuses on law, not facts, because it's a review of processes. So rather than looking at the substance of a decision itself, whether that decision is right, wrong, good, bad, what the court will be looking at is how that decision was actually reached. What process was followed? Was a process followed? Because unfortunately often one isn't. And was it followed in the proper manner as set out, whether by statute or internal policy or elsewhere? The court, when looking at an application for judicial review, really looks then at whether a decision was validly made. And as I've noted there, it's a remedy available only in the High Court. I want to come on to discuss the grounds for judicial review, but before I do, I think it's really important to keep in mind that the different grounds are layered and they're overlapping. For example, if an argument that comes up time and time again in the housing law context is that a public authority has taken into account factors that they really shouldn't have. For example, factors related to the personal characteristics somebody has under the Equality Act. That comes up time and time again. As I've said, in terms of grounds for judicial review, that can be framed in a number of different ways. So it could be framed as illegality, it could be framed as irrationality, it could be framed as procedural unfairness. That one act or set of circumstances could be framed in multiple different ways, and of course we're going to go through those different grounds in a moment. But just to say at the offset that really, in my view, the way to frame, or which ground to choose to frame your argument, will depend really on the sort of evidence that you're able to gather. But there's also some scope for tactics, in that some of the grounds, as we'll come on to discuss, are a little bit more difficult to make out, and grounds, for example, such as irrationality, where really the courts are a little bit more reluctant. So taking that overview into mind is something I would recommend before you start to frame any claim. So looking first and foremost at illegality. This is a substantive ground, meaning it looks at the substance of the actual decision rather than simply the process. And in short, illegality occurs where there's been a misapplication of the law. For example, misapplying the actual wording of a statutory process, sometimes a failure to apply it at all, or sometimes in cases where an authority might have acted beyond its powers. In short, the head here is to ensure that decision makers really understand the law that regulates them. So decision makers, for example, are regulated by the Equality Act. As we know, particularly relevant in this context, and one section that comes up most often is the public sector equality duty. Now, if that's something that simply hasn't been considered by a local authority or public body, there would be cause to argue potentially, or grounds to bring a claim in relation to illegality. It's also under this head that we find claims brought under the Human Rights Act, and where we get things such as the declarations of incompatibility that can arise where legislation isn't compatible with the Human Rights Act. In the housing law context, some of the main areas that come up here or the main arguments that come up are that local authorities and public bodies have fettered their discretion in some way. That comes up quite a lot, often because of unfortunate wording that decision makers might have included in their letters, including things such as, or in their letters or in their correspondence, where they make very clear that in X sort of cases we don't do Y, or we only do Z. That really opens up the pathway for someone to make an argument that discretion has been fettered. It's also under this head of illegality that we get the general public law principles being brought in. And these are relevant not just in the judicial review context, of course, but they arise often or can be seen in possession proceedings as defences to social housing possession proceedings. So those public law principles are really the general principles of fairness, including things such as taking into account all relevant information, not taking into account irrelevant information, and making sufficient inquiries. And I will speak very briefly to this inquiries point, because again, it's something that's come up time and time again in the sorts of cases that I've been seeing, and I act, to be clear, both on behalf of local authorities and also claimants bringing these judicial review claims. This argument being that sufficient inquiries have not been made by a local authority into the individual circumstances. It's very difficult to give a hard and fast view as to what is a sufficient level of inquiry, because of course the individual circumstances are what dictates that. But if I was to try and give a very brief overview of what to look for in those circumstances, if when you're reading over somebody's application, you're thinking to yourself that there's a question that you'd like answered about, for example, how a condition affects them, whether that condition has been properly diagnosed, these sorts of questions, then I would suggest that that indicates that you should be making further inquiries. You should be asking that question of somebody who's able to answer it, whether it's their GP or another service provider that they're engaged with. Generally, in relation to illegality, it would be my suggestion that this is a stronger ground when it comes to housing law applications, because it's really, in my view, a firmer basis for the claim. It's a little bit less subjective than some of the other grounds, because it is linked in to law, whereas the next ground we're going to look at, irrationality, is that bit more subjective. So looking at irrationality, and this might well be the ground that comes to mind for most of you when you think of judicial review, because I'm sure we all remember hearing the term Wednesbury unreasonableness as part of our law lectures. That has always been, when it comes to the ground of irrationality, the baseline test. And it's found in the case of Associated Provincial Picture Houses and Wednesbury Corporation, as is cited, I believe, in the handout. That classical formulation is effectively a decision that is so unreasonable that no reasonable authority could have taken it. But as I've set out in the handout, D. Smith's Guide to Judicial Review sets out a slightly different framing of what is Wednesbury unreasonable. And in my view, that's really a slight watering down, because the original or classic interpretation, so unreasonable no reasonable authority could have, really does or did set a very, very high bar. It's a difficult, it's a very difficult ground to make out, and one that I've not seen succeed very often. in my view, this slight watering down that we see, and I've set it out in the handout, that a claimant must show that the decision under challenge is outside of the range of reasonable responses of a public authority, is that slight bit of a lowering of the bar. That doesn't, however, change my view that this is a ground that effectively is difficult to make out, and not the first ground that I would advise somebody to plead, and definitely the first ground I would advise somebody to try and include in any defence. It's a really easy one to defend, because unless somebody's done something absolutely ludicrous, it's not going to be outside of that range. The courts are very slow to intervene because, in short, the decision makers in housing law cases, those local authority decision makers, are really the experts. The court's not there to substitute its view for the decision maker's view. So even if a judge might be convinced that, well, something else might have been slightly better, we're not going to get to that point of proving or demonstrating irrationality. Where it can be a little bit easier to succeed on this ground is if it can be very clearly shown that something that was irrelevant has been taken into account. That, as I've already covered when we looked at illegality, is something that I see pleaded all of the time, but very rarely have I seen it evidenced. It's difficult to evidence it, but if there is evidence that something irrelevant's been taken account of, then it would be likely that there might be some success under this ground. The next ground is procedural impropriety. This really comes down to fairness. That's what this ground's all about. Has a fair procedure been followed, whether that's the statutory procedure for making that decision, whether that's any own policies and procedures, or whether it's general natural justice ideas, such as the fact that an individual should be able to have an opportunity to make representations if a decision's being made which affects them. You would be surprised, or perhaps you wouldn't be, to know the amount of times I've seen local authorities who have often very detailed, clear and relevant policies in place to help and guide them to make decisions, not following their own policies. That happens, unfortunately, relatively often. So what I would advise anybody to do, if you're a local authority, first and foremost, is make sure that everybody who is making these decisions is well aware of the policies you have in place, training on those policies, etc. And if somebody is bringing a claim or thinking about bringing a claim, get straight onto those council policies. Most of them will be available on council websites, and use that as a base point for assessing whether a fair process has been followed. Now, I've included there the case of Doody, which sets out some of the principles that the court will look at when deciding whether a decision has been taken in a way that is procedurally fair. Again, it's a very context-driven view of things that the court takes, and the court will look at things in the round, taking, as they've set out in Doody, the statute as really the starting point. So again, this is another ground that, in my view, is that little bit more concrete than something like irrationality, which, for whatever reason, seems to be the favoured pleading, but simply isn't the easiest one to make out, and isn't the one that's going to most likely persuade a judge. Because with this fairness, procedural propriety ground, you're grounding, or you can ground whatever submissions you want to make by not only looking at internal policies, but also statutory procedures. And as they recognise in Doody, that will be the starting point for the court. The court in Doody also recognised very clearly that just because there might have been a better way to make a decision, a better process that might have been clearer, easier for the person involved to navigate, etc., doesn't mean that you're going to get success on this ground. So you might well show that really it would have been better if the local authority did X, Y, and Z, as long as what the local authority did do is sufficient, it doesn't have to be the best way. Now, I'm going to touch very briefly on the next ground of legitimate expectation, because it's not one that arises all that often in the housing context, although again it's worth having a note of because it can arise. Effectively, a public body might, by its own statement or conduct, be required to act in a certain way if they have created a legitimate expectation because of the way they have communicated, for example. A really easy example of this, again, brings up the policies that local authorities have. So as I set out at the outset, a lot of these grounds, they bleed into each other and they overlap. So if we've got a local authority that isn't following its own internal policies, there would also potentially be a basis for pleading a ground of breach of legitimate expectation, because an applicant might well have decided or have expected rather a local authority to take certain steps in making their decision, and if they haven't been followed, that legitimate expectation may well have been breached. The case of R and Devon County Council ex parte Barker is relevant here. It sets out that if a clear and unambiguous representation without qualification is given, that a particular procedure will be followed, that is enough to create this legitimate expectation. So again, if it's set out in your policy that you're going to consider these three factors, and you then can't evidence that you've done that, you're going to be potentially in trouble as a local authority, and you're going to potentially have grounds if you're an individual wishing to bring a claim. A relevant case that's worth mentioning here in the housing context is the case of R and North East Devon Authority ex parte Coughlin, 2001 QB 213. And that's a Court of Appeals decision that actually is looking at a health authority's promise in relation to housing. That in that case, the health authority had promised to an individual who had complex care needs that they would be housed for life in a particular housing and health context. That then didn't come to fruition. They were asked to move on after a certain number of years, and the Court of Appeal found that they had very clearly told this individual that they would be housed for life, created a legitimate expectation, and they'd breached that legitimate expectation in then reneging and trying to move this individual. Before we move on to look at some pre-action considerations, I've set out in the handout some typical housing law scenarios where judicial review might become relevant. I'm not going to list them all, but in general, areas to sort of look out for, or the headlines would be decisions around interim accommodation. That comes up it can come up in relation to suitability. It can also come up where a local authority, there's a dispute about whether to provide interim accommodation pending review. It doesn't come up often. Most local authorities know that they need to provide interim accommodation pending review, or will, in order to not run this risk of being challenged, but it's something to note. The other area where this comes up reasonably often is where new information comes to light in relation to an applicant, or there is a change in their circumstances. So, for example, a homeless applicant has applied, they've either had their duty discharged or been found not to be owed a duty, and then there's a change in circumstances, for example, a new medical diagnosis that has an impact or would have an impact on that housing decision. Local authorities at that point should be looking to reassess, and there can be cases where there's a dispute about whether that new information is something that re-triggers the duty or not. Now, looking at some pre-action considerations. The first one is to look at whether all other remedies have been exhausted. Judicial review is an application or a remedy of last resort. So if there's another way that an individual can challenge their problem, then this shouldn't be coming to judicial review. If you make an application for judicial review, having not exhausted your other remedies, you'll fall at the first hurdle, as you won't be granted permission by the High Court. In the housing context, the main thing to look for is whether this is something that can be challenged under Section 204. The next issue is one of timing. There is a very tight deadline for bringing judicial review claims. CPR Part 54 is the CPR rule to look at, and more specifically CPR Rule 54.51A, which sets the primary test, which is promptly. So any claim for judicial review should be brought promptly. Rule 54.51B, and in any event within 3 months. So it's often said that the deadline is 3 months. That is the case, but promptly is the primary test. And there is case law where it has been found that a judicial review brought within that 3 months, but not promptly, has fallen at this hurdle as it's not been brought in time. And finally, consider is the pre-action protocol. Again here, the context is really everything in terms of housing claims, and that's noted in the pre-action protocol at paragraph 6. It sets out very clearly and recognises that often in certain contexts there will be a sense of urgency. That means that although sending letters before action, asking for information, waiting for responses is going to be the desirable way forward to avoid litigation, the reality, if somebody is homeless or threatened with imminent homelessness, means that we can't wait to go through that procedure. So paragraph 6 sets out very clearly that in those circumstances, the urgency means that the protocol doesn't need to be followed to the letter, and instead it recommends doing what I would call common sense things, such as picking up the phone to the other side, sending them an email, sending them a fax, warning them that they're going to be getting these grounds sent through to them. The pre-action protocol also deals briefly with the usual things we'd expect to see in a pre-action protocol, ADR, requests for info, and then it also sets out what to include in letters before action and any response. How to apply for judicial review. But the main thing to speak about really is the statement of grounds. That statement, certainly in my view and my advice, would be that it should be a short, punchy statement if possible. So you've got your statement of facts. That can set out the detail because, of course, there can be a complex factual background if you're making or bringing a claim for judicial review. Often individuals might have a lengthy history of engagement with local authorities, as well as very complex personal circumstances, multiple medical diagnoses, as well as factually a difficult background in relation to their housing. All of that, however, should go in, as I've said, the statement of facts. These grounds should be as short and punchy as possible, setting out what we say the grounds are, setting out any law that supports that, any policy. If, for example, we're saying that the internal policy hasn't been followed, set out a section of that policy, set out how, and that's really all it needs to say on that point. So often you can get 20, 30 page long grounds for judicial review, and in my view, of course, there are cases where that's warranted and necessary, but the majority of the time in a housing context, that's not going to be the case. How to defend any application for judicial review then. And the main headline here is around gathering documentation. So it's not just looking at the actual substance of any decision that's been made, but also looking back to what is in the housing file and what we can demonstrate as a local authority that we have done. So the housing file often can help fill in any gaps that there might be in a decision letter and show, for example, that inquiries were made, that those things were considered. As well as then, as I've already indicated, looking back at any policies and procedures that the local authority has, any notes, any communications with the individual. And then coming on briefly to remedies. There are a number of remedies. I've included what I would call the big four in the housing context. The first one being a quashing order. And really, 9 times out of 10, that's, in my experience, what an applicant is looking for. An order really to quash any decision, meaning it won't have any effect, either retroactively or prospectively. It's as though that decision hasn't been made. We're rubbing it out and we're starting again. In terms of local authorities then and how they should approach judicial review, it's worth keeping firmly in mind that most of the time this is what applicants, claimants are wanting, simply for that decision to be taken again. So in terms of looking at how and when to defend, it might well be a case that if there are question marks and we're not sure, or we think there might be some way in which the decision could potentially be defective, it would, in my view, make much more sense to go back and retake the decision than go through the lengthy and potentially costly process of going through the court procedure and defending it, when in reality it might be half a day's work for somebody to remedy any defects in the original decision. Mandatory orders, they do what they say on the tin. They make mandatory an action to be taken. So for example, you'll often get a quashing order made with a mandatory order, so an order quashing the original decision and a mandatory order ordering that the local authority retakes the decision. Prohibitory orders in this context would be made, for example, if there's a threat to somebody losing their accommodation or interim accommodation while decisions are being taken. And it's worth noting that injunctions can be made in judicial review proceedings. So rather than waiting for the final hearing, where a mandatory or prohibitory order might be made, an injunction might be made at the permission stage, for example, that maintains the status quo and ensures that a person isn't made homeless. Declarations are also available in this context, but really there's something that the court will try to avoid making. It rarely happens in the housing context, as effectively what a judge will often say is that their decision is the declaration, because a declaration will only set out what the law is, and that should be really included in the decision. Damages I have included here. They're not actually a separate remedy available in judicial review proceedings, but they do come up often. As often in these judicial review claims, there's a Human Rights Act claim or a Equality Act claim running alongside and as part of, and of course damages are available if somebody succeeds under that head. But there has been an update or change to the law in the form of the Judicial Review and Courts Act 2022, which came into force in April 2022. And added new remedies, really, that courts can consider in the judicial review context. The first is that courts are now able to make suspended quashing orders. And the second is that courts are also able to make prospective only quashing orders. So that would be a quashing order that means that the decision is still valid to the date of the order, but going forward the decision is no longer valid. And I've seen a couple of furrowed brows there. I'm not really sure how that's going to work either, or what on earth the relevance would be in this context. There's very, very little case law on it, full stop. It doesn't seem that the courts are jumping in and starting to use these new remedies. I haven't been able to find any case law showing their use in a housing law context, and so I haven't dedicated a lot of time to it, but just so that it's on your radar that these are things the courts can do. I think there was a moment of madness before the Law Society stepped in, where the Act was going to make these two types of order the default, and effectively there was going to be a statutory presumption that this is what judges would do when they saw an application for judicial review, make one of these orders. As I said, the Law Society stepped in, told them that was utter madness. And so things so far have effectively remained the same. Now, I've included a few top tips. The first is around record keeping. And And that goes for both sides. If you're an applicant, keeping a note of when you've spoken to somebody at a local authority, who you've spoken to and what they've told you, but also if you're a local authority and you're getting an application in, making sure you're looking over all of your notes. Legal advice, it's important to consult with colleagues or seek specialist legal advice if there is any confusion. Client communications, and really this is an important point, to ensure that the client understands the process, and again that goes for both sides of the fence, whether that's a housing law client, a housing department in the local authority, or an individual. This is particularly relevant again with quashing orders, as often if all it takes is to remake a decision and make it in clearer meat terms, it might be worth considering. Training, again, a point I made earlier, make sure everybody understands and knows the policies at the local authority. And early engagement.